and welcome to Woo Stream, bringing Willamette to you. My name's Tiffany Newton. I'm the Director of Graduate Alumni Engagement here at Willamette. Today's conversation features Andrew Gilden, Assistant Professor of Law for Willamette University's College of Law. His research focuses on intellectual property and internet law, as well as legal issues concerning free speech, civil rights, gender identity, and sexual orientation. Before joining Willamette University College of Law, Gilden was a Thomas C. Gray Fellow and Lecturer of Law at Stanford University, where he taught social media law, intellectual property counseling, federal litigation, and legal research and writing. Professor Gilden will discuss his research in internet law, including case reviews and discussions about the intricacies of controlling social media accounts after someone has passed away, with a look at some high-profile incidents you may have read about recently. Professor Gilden, thank you so much for joining us this evening.
Well, thank you so much for having me on the Woo stream, and it's nice to see some familiar names here. I'm excited to talk to you about some of my recent work, and again, it's really at the intersection of internet law, intellectual property, and trust and estates. And I've published several articles at this intersection, but what I'm going to really focus on today is a recent publication in the Harvard Journal of Law and Technology, which I call The Social Afterlife. In this research, I examine a few questions that really interest me. First, who gets to make decisions about how a person is remembered after they're gone? And I call this someone's cultural legacy. And what does good postmortem decision-making, which I like to think of as legacy stewardship, what does it look like in the age of social media and advanced digital technologies? So if we take, for example, the Prince estate, who should decide whether his hologram plays at the Super Bowl? Who should decide what happens to his social media accounts? Who should decide what will happen to his previously recorded but unreleased music, whether it's stored in the cloud or in a secured vault underneath Paisley Park? And who should decide whether his Paisley Park mansion turns into a museum open to the public? Then, outside of the celebrity context, should a surviving spouse and their sole heir take control over a decedent's Facebook account? And should different apps, perhaps ones that contain very private information like Tinder or Grindr, hand the keys over to that person's children? So these questions implicate the very least four areas of law: trust and estates, copyright law, rights of publicity, and the new body of digital asset laws. So trust and estates, which is the law of wills, trusts, and intestate succession, they largely determine who controls the decedent's real and personal property. Copyright law, which has special rules of inheritance and succession, determines who controls the writings, music, photographs, etc., that are created by the decedent. State law rights of publicity determine who controls the commercial use of a person's name, image, or likeness. And then, as I mentioned, there's this new body of law called digital asset law that determines how online accounts and the data contained within those accounts gets disposed of once the account holder dies. So each of these areas of law approaches questions of what I call legacy stewardship quite differently, and places primary decision-making authority in a different entity, which creates a whole lot of doctrinal tensions and conflicts. And on top of these doctrinal tensions, none of these areas actually provides clear guidance on how the appointed steward should go about addressing some of these difficult questions. The traditional goals of good estate planning have tended to be about maximizing the value of the estate and minimizing transaction costs, with the goal of kind of extracting as much value as you can out of the decedent's assets, and then distributing them to their heirs as efficiently as possible. But these financial concerns, these economic concerns, don't really carry over well to the stewardship issues I'm concerned with. How to address a person's ongoing kind of cultural and emotional legacy, how someone is remembered and continues to factor into lives of those left behind. So what I do in this article is two things. First, I bring these areas of law into much needed conversation, and I identify several models of stewardship that appear within them. And then secondly, I synthesize what I think is a better model that better reflects the emerging and complex challenges of confronting the social afterlife. So the bulk of the paper looks at these four areas of law and identifies what I think are four approaches to postmortem decision making. And I'm going to walk through each of them and then give some pros and cons to each approach. So the first model is the freedom of disposition model. If you've taken Trust in the States with me, you've heard this term a lot. And the basic idea is that a person is best positioned to make decisions about their own legacy during their lifetime. And this is the dominant model in the law of wills and trusts, where there are relatively few limits on the ability for someone to decide how their real and personal property will be used after they die. You can completely disinherit your kids if you want. You can set up $1 million trust to take care of your cat. It's really father or mother knows best. The pros, the advantages of this model is that the decedent probably knows themselves and the needs of their survivors better than anyone else. And if you can shape your own legacy, you are, at least the argument goes, that you're probably incentivized to engage in some productive lifetime activities if you know it's going to be put towards some valuable use after you die. The disadvantages is that most people don't actually exercise this freedom of disposition and make a plan for their afterlife, social or otherwise. A recent, the main survey on estate planning shows that only about a third of Americans have a formal estate plan, and that number has continued to drop year by year. And even if you do exercise this freedom of disposition, you can't anticipate either the social or technological changes that are going to come after you die, like, for example, being resurrected in hologram form. And on top of that, dead people don't bear the cost of bad decisions. So if you name your dumb kid as your literary agent and they shut down biographies and follow on creativity, you're never going to know. The next model is what I call the family inheritance model, that close family members are best positioned to make decisions about their loved one's legacy because of their close emotional and economic connections. And this model appears in a few important places. So the law of intestacy, basically the default rules when you don't have a will, gives default control to family members and is protective of particularly spouses who can't be totally disinherited. Copyright law has what's known as a termination of transfer provision. It's confusing, but it gives spouses and children and grandchildren a right to terminate the author's publishing, recording, or other contractual deals at certain time periods to make sure that they can reclaim control. The rights of publicity in some states, such as Virginia, only give the right to object or consent to commercial uses of the decedent's image, again, only to a spouse or the next of kin. In some European countries, family members are entitled as a default to access the family member's email and social media accounts. Only one state does that in the US, and that is Delaware. And I suspect that will not be for that much longer. So what is good about family inheritance model or family stewardship is that there really is often a strong emotional bond that motivates people to actively protect their loved one's legacy and reputation. And compared with other potential stakeholders, family members are likely the most familiar with the wishes of the decedent. But all of these advantages are also disadvantages. Family members are often so bound up in their own mourning and attachments that they fail to appreciate the wider range of stakeholders in how a person is remembered. Intellectual property estates are often notoriously stingy in giving permissions for follow-on uses of copyrighted works, are often hostile to uses by fans, scholars, other artists. And often family members are not as familiar with their loved ones as they may think they are. Oftentimes, family members are out of touch with the norms of creative and cultural communities, and I think more seriously, may be quite surprised by what they learned from a parent or child or spouse's email, Dropbox, or Tinder accounts. Death is unfortunately often a moment of what privacy scholars call context collapse. And the idea there is that during our lives, we create boundaries around different facets of our lives, particularly around questions of sexuality, but also around fandom and creative communities. And death is a time when these walls can kind of come crashing down, really to the detriment of everyone. And the third model is the public domain model. And this is, rather than give control to any one particular entity, a person's legacy should be shaped by the public at large. And the public domain model appears in a few places. So in some states do not have a right of publicity that extends post-mortem, meaning that, for example, if someone dies in the state of New York, that their name, image, or likeness is available for all to use after their death. Some European jurisdictions have no data privacy protections for the deceased, and in all but one U.S. state, this time Rhode Island, you are free to defame the dead. And in Rhode Island, it's actually only 3 months where that's unlawful. So the advantages of the public domain model. So we like public stewardship for all the reasons that us copyright geeks like the public domain and the commons generally. Public domain is pretty good for encouraging preservation of works, for expanding public knowledge. But the problem, though, is that the public often doesn't care very much about the privacy interests of the deceased, particularly famous decedents. And when someone dies, we often want to know every last juicy detail about them, and often the public downplays the impact that these types of revelations might have on those who do have very close personal connections with the deceased. And then finally is the consumer contract model. This is probably the least intuitive, but the idea here is that we should place stewardship in the hands of commercial intermediaries, such as social media platforms, because one, they know a lot about the people who sign up for their services, and they have market incentives to balance the interests of a deceased user against their families, against all the other users on the platform. So notwithstanding, I think, many solid reasons to be skeptical about this consumer contract model, it is nonetheless now the dominant approach to digital assets across the United States. So what I'm going to do now is walk us through the revised Uniform Fiduciary Access to Digital Assets Act, better known as RUFADA, which despite its deeply unsexy name, it has been passed in over 40 states. I think we're actually at like 45 or 46 states just since 2016. And so what I'm going to do is walk us through this model because it's probably new to most of you, and it's kind of weird in light of everything else you may know about wills, trusts, and estate planning. So basically, in the absence of a will or trust, a social media platform or any sort of online platform's terms of service control. So, for example, if the dating app Tinder's terms of service can say, for example, that it will delete all account data upon learning of the user's death. It doesn't matter if, let's say, a surviving spouse wants to see what their spouse was doing on this dating app. However, if the decedent does have a will or trust that expressly addresses digital assets, they say, yeah, I want the executor of my estate or my spouse to have full access to all my digital accounts. This will trump or supersede the terms of service on the website or the social media platform. However, the social media platform can trump a user's will or trust by providing the decedent with what's known as an online tool. It is basically a form on the website or the app that allows the user to direct what happens to their accounts post-mortem. And these online tools, again, supersede someone's express provision of a will or trust. So the way this works, and here are some examples here. So if the decedent listed their, let's say, best friend as their legacy contact on Facebook, their torts professor as their inactive account manager in Gmail, and let's say a fellow Harry Potter fan as their vanished next of kin. It doesn't matter that the decedent's will expressly gave, let's say, their spouse access to Facebook, Gmail, and fan fiction. These online tools supersede whatever exists in the will. So with these digital asset laws with RUFADA, market actors have tremendous control over how data is accessed and used postmortem, both through the terms of service and through providing these online tools. So for this one, I'm going to start with reasons to be skeptical of the consumer contract model. So first of all, there's a potential here to completely cut out families from postmortem decision making. And it places a lot of trust in companies whose financial interest may often clips their incentives to be good stewards. I think many of us would be uncomfortable sort of naming Mark Zuckerberg or Jack Dorsey as the executors of our estate. And in a way, that's what this does. But there are some real reasons to be optimistic about the consumer contract model. So although there are certainly, let's say, issues with Facebook's data retention policies and their privacy practices. In designing that legacy contact tool that I put up on the previous slide, Facebook hired a group of expert social scientists who carefully researched community preference around how to best to deal with access to Facebook accounts postmortem. And if we give decision-making power to different market actors, we can end up with stewardship decisions that are heterogeneous across platforms and better tailored to a particular context. So, if you're Facebook or you're LinkedIn or you're Tinder, you may justifiably have different sets of defaults about what happens to users' accounts when they die. Also, intermediaries are really well positioned to nudge users towards actually making decisions about their social afterlife. So, these platforms are literally in our faces for maybe say hopefully no more than 16 hours a day, but maybe that much as well. And as a result, people may be reluctant to execute a will, but they may be much more likely to basically click a few boxes and reveal what their preferences are. And we may prefer the will, but to whatever extent we can actually reveal people's preferences, that's better than nothing. Okay, so what to make of this? So after walking through these four models, the paper pulls out, I think, are five important principles of effective stewardship in the digital context. So first, people live in dispersed social contexts, both in the physical world and very much online. And these contexts are often subject to diverse social norms. Ideally, decisions should be made by individuals who are familiar with each of those contexts and their associated norms. At the same time, I think it's important to recognize that certain people are economically and or emotionally dependent on the decedent and may be particularly vulnerable postmortem to exploitation. Also, it's important to recognize the potential for conflicts of interest, which might make stewards put their own needs over loyalty to those they are supposed to be acting on behalf of. So from these principles, I synthesize a new model, which I'm calling the decentered decedent, which works on paper, but it's very hard to say fast. The idea is that we should empower decedents to tailor decision-making to those different contexts. Often this will involve selecting a family member to make important decisions, but in the absence of such deliberate selection, we should elevate other stakeholders, communities, courts, the public. So the Rufada has been criticized as giving too much power to tech giants and for taking control away from families. But its decentralized approach, again, different rules for different platforms, may better reflect the privacy interest of internet users and help avoid some of the context collapse that often occurs when people die. So if we embrace what I'm calling the decentered decedent, it might result in a number of reforms, which I've grouped into three categories. The first is what I call contextual testation. So rather than try to centralize all postmortem decision-making, all estate plans in a single document like a will, or appoint a single executor to decide everything, my model encourages individuals to treat different contexts differently. So I think this online tools idea is actually really rich, and that they could be made much more salient. They can be made much more salient than they currently are. I suggest that there are key moments in the acquisition and the negotiation of property interests where we should try to get individuals to think about and express their preferences about what they want to happen to their property interest at death. So, for example, when you register your copyrighted work, the Copyright Office might ask you to list a post-mortem steward, and this could be given some sort of legal effect. So, a lot of problems in the copyright context come from celebrity artists who die without a will, and then their families, let's say it's Prince or it's Marvin Gaye, essentially get control over a family business that they didn't ask for and that they may not be all that well equipped to manage. I also suggest that we may want to disaggregate compensation from control. So a lot of the bad stewardship decisions we see comes from giving authority to family members, again, like the Prince and Marvin Gaye estates, who are economically dependent on the decedent, but don't really know that much about the sort of cultural context in which they're operating. So ideally, we would try to channel some money to these folks without necessarily giving them ultimate control over the legacy. And then finally, in terms of my reforms, I think we do need to do something about potential conflicts of interest with intermediaries. I think we might want to add some substance in terms of what needs to go into these online tools. Right now, it's totally up to the platform to decide what options to provide and what questions to ask. There's been some discussion both in legislation, but in a lot of legal scholarship around imposing some sort of fiduciary duties on online intermediaries when dealing with your users' data. And lastly, I do think there needs to be some opportunity to challenge stewardship decisions ex post and allow some case-by-case review into the digital asset realms to assess situations where there is some hardship that stems from a particular decision. And actually, in the past year, a lot of this actually is, since I wrote the article, we've started to actually see something along these lines emerging in probate courts. So what I want to do is to end my talk by discussing just two of these recent cases to show how courts have started to grapple with access to digital assets. In the past year, there have been a number of published decisions coming from New York Surrogacy Court addressing whether a surviving family member should get access to a decedent's Apple iCloud account. So where an estate representative wants to access, let's say, the decedent's photos or their text messages or other content from their iPhone. Apple's policy is generally to require a court to order them to disclose that content if it deems it to be appropriate. So we have the matter of Scandalios, which would be slightly less scandalous than it sounds, but nonetheless, in this case, we have a surviving spouse who requested access to their deceased spouse's iCloud account, purportedly to access family photos. And although there was no express authorization in a will or a trust or an online tool, the court did nonetheless order Apple to allow the surviving spouse to reset the iCloud password and access the decedent's iCloud account. So the court emphasized that the decedent had implicitly consented to allow their spouse to access his account based upon the fact that their computers were adjacent to each other, and that they never tried to shield what they were doing from each other. So on one hand, I think it's a good thing that courts are providing some, an avenue for family members to access otherwise lost photos. But the evidence of what the decedent wanted in this case was pretty thin. And access to someone's iCloud account means access to much more than just a few selected photos. So then we contrast this case with the matter of Coleman. In this case involved a year-old who died mysteriously in his sleep, and the cause of death was inconclusive. So his parents sought access to his iCloud account, but again, Apple said, go to court, obtain an order in order for us to give you this information. And here, the court denied access. And it was concerned, apparently, that the intrusion on the decedent's privacy outweighed any benefit to estate administration. So I think these are really hard cases. I think a lot of the uncertainty could be avoided by making questions of death and incapacity and legacy stewardship much more salient when we sign up for these accounts and subsequently acquire emotionally valuable property interests. So I think I will end there. And I'm happy to explain any part of this research. I look forward to your comments. This is a Robert Kardashian posthumous hologram because I thought it'd be fun to put up on the screen. But I look forward to hearing your thoughts and questions.
Have you seen decisions or some conversations, especially around sexual identity, orientation, presentation? There are a lot of folks for safety reasons or for a variety of reasons who maybe would not out themselves to family members or have a life and have a family of very close people that know them in one context versus their birth family. And I wonder if you've seen that come up.
So it hasn't. So first of all, there aren't that many of these cases yet. A lot of, this happens a lot. Getting a digital assets order, that happens quite often, but there isn't that much published case law about comes from the probate court. But nonetheless, I think those concerns are really what is driving the difference between this case and this case. Where in this case, we have a 24-year-old college student, and their parents want to sort of get access to their accounts. I think the questions about sort of self-discovery and sort of figuring things out for yourself when you're 24 years old, and maybe some sort of boundary between your parents is more important than perhaps, I think, what in the Coleman case, they're saying, they were married, they shared space, that concern about sort of context collapse was less salient. Although I should note that there are lots of situations where people find out that their spouses have led some surprising lives, when it comes to administering their estate. So the court maybe is being a little rosy in the picture that's painting of everyone here. But the concern, I think, around identity and sexuality, I think, are really quite important when we're dealing with young people's social media accounts.
Thank you for that. Another question that just came in is, what happens to one's digital content if no family member claims it and there were no provisions made for it in a will or digital tool? Can others claim it? Who might step into that role?
Yeah, so that's a situation where every platform has their own set of rules. So Facebook's default is, once it learns of a user's death, the account will become memorialized, which basically means it gets locked. There's sort of very limited types of posts can be made. So basically, I mean, there's a lot of discussion about, like, Facebook is going to get to a point where it becomes more of a graveyard than anything else. That basically there's going to be just tons and tons and tons or millions, if not billions, of deceased users, because their policy is to memorialize accounts. Other platforms I believe Twitter. I believe Twitter will terminate the account at some point, but that policy has shifted over time. But essentially, it is entirely up to the platform about what happens in terms of access to the account. Some platforms will terminate the accounts. Others will leave them standing. But the most common thing is that there's going to be some period of kind of limbo where we're not quite sure what's going on in those accounts, which is why, if you have a Facebook account, go choose a legacy contact. Many of us use Gmail. You can go to an inactive account manager and save your loved ones some difficulty.
And there's probably so much that we almost need a guide on how to do that on all of these different sites. Another person is asking if there are potential competing interests between intellectual property and digital. For, in this case, a musician that writes and performs original music who posts videos on Facebook. Are those addressed separately under IP and digital law, or are these bodies of law and resultant effects merging?
So copyright law, technically what it does is it allows you to stop others from making copies of your work. It does not entitle you to actually access the files that are held on someone else's server. So, particularly in the Apple context, we take a photo on our camera, it gets uploaded to Apple servers. We have copyright interests in those pictures. But if you don't have the password to the account or you're locked out, you don't have access to your own work. So the question of access to materials and the ability to copy those materials are entirely separate questions. And what's frustrating is that a family member can, and this is getting a little bit into the weeds, can terminate a copyright grant 35 years after it happened. But that doesn't mean that they can force Apple to hand over access to the copy. So again, it's these issues intersect, but they have not sort of developed succession rules based upon any sort of integrated approach. So these questions intersect all the time in practice, but these are areas of law that have developed on parallel tracks. And what the internet does is it just collides them all together. One thing I'm trying to do with my work is to sort of make that intersection something that's more on people's radar. Trust in estates folks and intellectual property folks don't hang out at the same bars too often, and I think they should.
Well, and it all seems to provide a little bit more clarity and to kind of help people navigate this themselves. Another question that came in is kind of comparing what's happening in the US and if you know a bit more about what's happening abroad. They said they have friends in Europe and Asia who've shared that they believe that they're technologically ahead of where the US is. And they were just kind of wondering if you've seen international examples where we are making much different decisions than how this is handled in a different country.
Yeah, so I mean, there are many different approaches to this. I think the clearest contrast is between the U.S. and Germany. So appellate court in Germany said that a parent inherits access to their kid's Facebook account the same way they would inherit access to their physical letters. And granted, Germany has, the continent of Europe has much more of a sense of a right to inherit than the US does. The US is much more about the right to decide what happens to your works. So the continental European approach does tend to give families more of a presumed access. That contrast with that is that there are a scattering of other European jurisdictions, and I don't want to misstate Estonian law on the record, but that again the big privacy law that applies in Europe, the GDPR, expressly says that it's up to each member state to make their own rules about dead people's privacy. So as a result, that Europe, while it's generally fairly uniform in terms of privacy, data privacy generally, this is one area where it's a patchwork.
Another thing when speaking about a particular context in this question, really about thinking about the family unit and how we're all adapting and adopting new technologies and kind of learning things. How would you recommend broaching this subject with, say, an aging parent who may not understand the importance of passwords or digital asset ownership, and trying not to lose some of the family photos they've shared or things that would be meaningful to others that are left behind after they pass?
Last year, when I was, or I guess more than a year ago at this point, sadly, I was seeing, I saw my parents. I noticed my mother had this little box of little paper cards, little note cards that had all of her passwords written on them. And I said, it's great that there's one place that we can all go to sort of know what the passwords are. But when you actually do go about making your will or amending the will, just mentioning something about digital assets and social media accounts, like a single sentence can do a lot of work. I mean, if you're someone who really doesn't, if you really just don't care that much about sort of carefully dissecting different contexts, then just a single sentence that authorizes whoever you list as your executor to be to have access to your digital accounts, that can go a long way to make sure that they don't have to go to court, so that they can get the photos in the iCloud. So basically, if you have a relative who is thinking about estate plans, then just raising the issue of digital assets should be enough, and just get it on the radar. Because estate planners, I think, are increasingly aware of this. But if you had a will that was executed, let's say before 2016, the ability to actually be confident that your desire to that the digital asset provision will be enforceable was unclear. But now, unless you live in Delaware, it's pretty clear that those types of provisions will be enforced.
Another question kind of builds on the one earlier, where maybe there wasn't a family member or someone designated to have control of the media assets. And this person asks, is there a proactive reason not to join a particular social media platform? That is, should, for instance, estate attorneys discourage individuals from interacting with certain social media?
I'd say the reason beyond what happens when you die, to avoid social media accounts, that what you post on the internet stays on the internet, and whatever you do on someone else's, as much as there's lots of discussion right now about about Twitter censorship and Facebook censorship, these are private platforms that can do what they want, and you're operating under their rules. Those terms of service that we scroll through and don't read do affect our ability to control information about us, to what other people can do, often with stuff that we post. we are giving licenses to these companies to use our tweets, use our uploaded photos, etc. So if in doubt, don't post. And and so even if something feels private, there are like everything on the internet is a little bit leaky, and it can leak because of Facebook wants to is going to sell your data to as part of his business model, or it's possible that some companies may have a more relaxed rule about family access to your accounts after they die. So if Apple, if they wanted to, could have a more lenient policy than it does. There's some hacking issues that I don't want to confuse everyone with, but again, you are really anything you put on the internet is subject to someone else's rules.
Speaking of that, it just seems like there's so much information to learn. There's all of these different context that might come into that decision making. Is there a place for folks to go that really talks about social media literacy, about privacy, about some of this stuff, so that you can be a more informed user? Because honestly, not everyone, people flick through the terms of service and don't often read the contracts or the conditions that they're agreeing to.
Yeah. So one, you can follow me on Twitter, and two, there are. I mean, basically, if you do like a Google search for something like a digital undertaker or digital asset services, there are tons of websites that walk you that will walk you through this. So I provide, I think, a needed scholarly approach to this. But there are tons of websites that provide sort of practical guides for digital assets. I believe the Oregon State Bar has information that's Oregon specific and gives some model language and some sort of tips for estate planning. So the resources are widely available. If anyone watching, wants sort of more specific guidance, they're welcome to email me or tweet at me, and I can blow your mind.
Are there any examples where you've seen this go really well or really wrong that you want to share? I mean, you gave, two small examples, but are there any that you've seen that have really kind of made you think differently about this or brought it more finer to your attention?
So this is maybe be slightly controversial, but actually one of the better sort of handoffs in the realm has actually has been with Herman Cain and his accounts. So there was some argument like Herman Cain continues to tweet after he dies, like this is crazy, but actually his family members have been very sort of upfront about what he had expressly discussed, that he wanted his family members to kind of take over his social media accounts and to continue to tweet about the causes that he supported and the candidates that he supports, and regardless of whether you agree with Herman Cain or not, there was deliberate decisions about the kind of handoff to the next generation. And I think that's what ideally more people would do, because a lot of times actually, if you go, this is kind of gets to the project I'm working on now. If you look at basically, pick a dead celebrity of your choice, go to their Instagram account, and you'll see it's checkmark verified, the authentic account of Marilyn Monroe or Elvis Presley or Muhammad Ali, and you have no idea kind of who is pulling the strings there. And oftentimes it's, like, is it a family member? Is it sort of just a stale account? Or is it some third-party corporation who has bought that person's rights and now is, the official account holder? And what's going on behind the scenes in social media account management is really opaque. And I think that's and what I'm trying to do here is to sort of make things transparent, make things deliberate, so that everyone is aware what's going to happen, rather than having us be in this sort of limbo where consumers are confused, families are upset, um,
Mm.
and I guess keeps me writing.
Well, it seems like this is an issue that will continue to develop. Are there some aspects of this that you think could have more clarity in the near future, or things that you are going to be looking at next when you think about all the different issues that you've touched on?
I would really love, actually, I do think that the social media verification rules could be much more transparent. I actually think I think the opacity around sort of who controls accounts, I think gets into consumer protection issues, gets into false advertising questions, and I think some greater scrutiny about what is actually communicated by that blue check mark it would be really helpful. And I don't know if the Federal Trade Commission has been relatively active in the sort of false influencing, false advertising space online, and I do think the sort of that the blue checkmark does a lot of kind of work in the minds of consumers, and I think we could bring more attention to that. Again, that's not this paper, but it's something I'm working on now.
That's interesting, because I'm not sure that I've even personally thought of what the blue check mark means. Do you have like a quick summary of like what, does no one know quite what that means?
So I'm trying to remember the language of it, Ted, but basically, like it signals that it is the authentic presence of the individual or brand it represents. And the weird thing is that sometimes we're dealing with celebrities, what is the line between individual and brand gets really blurry. And you know, there's been sort of criticism about like no one knows about what exactly the thresholds are for sort of being popular enough to get the verification.
Mm-hmm.
Then on top of that, sort of what do we do when there is sort of a change of sort of a change in control, which happens when someone dies, about okay, someone has inherited a verified account. Is it still authentic? And I think it may depend on who that person is. I'm not aware, and I think this would actually be an area for some empirical work to get a better sense about what users think when they see a check mark next to a dead person who is tweeting today.
Interesting. And another question that just came in, other than the terms of service by a tech company, what is the real world difference between someone, say, hiding a secret love affair electronically versus keeping, secret love notes in a box in a closet? In other words, why does public policy seem to care so much more about information existing and being discovered digitally?
Yeah, I think it's largely a matter of scope. There's a matter of scope, is that our we can do we can do a lot more via digital messages than we can through relying on the postal service. So I think there's a matter of just like the scale of it, and just like the amount of information and the amount of sort of private moments that can be revealed in the digital context, just so much greater than there are from a box of letters. Also, it's a lot easier to destroy a box of letters than it is to permanently destroy what's going on someone else's servers. Also, I think there are real, and that's something else I've written about is that there are some real concerns about misinterpretation about some sort of text message exchange with emojis, or that someone has signed up for a swingers website, and then their spouse finds out about it. What can we actually glean from the account access? Less than you may think. So basically, that there is just the issue with the letters is, it's real, and it has happened that people sort of learn things through kind of rummaging through a loved one's desk drawer. But this is a desk drawer that is, let's say, the size of a warehouse, and harder to decode.
And like you said, the sheer volume in it can follow us for lifetimes. I mean, I can't imagine going back to MySpace or some previous iteration of a social media tool a lot of us used, and figuring out what is still on there. Thank you all so much for joining us. Andrew, is there anything you kind of want to make sure that you share with us about this topic? What's up next for you in research? Anything else before we kind of close out here?
Yeah, so as I mentioned, like my research is going in this direction of really sort of digging into what's weirdly called posthumous endorsement. Basically, I have a paper that it's almost ready for prime time about again about the perceptions of endorsement by deceased people, particularly when you go on social media and see deceased celebrities promoting everything from Walmart perfumes to Black Lives Matter. What does that mean? So that's where my work is going. So keep a lookout for that. That will be probably posted in a couple months. And my takeaway is that when you close this screen, log on and go over to the Facebook, which you might be looking at already, and go into your account settings. Look for your legacy contact, and it just takes a few steps to make a binding estate plan, and then you can tell everyone I have a plan for the future. Thank you so much for hosting this, and it's great to see again so many familiar names in the participants, and thank you everyone for your questions.
Thank you so much for your time and just knowledge and insight into all these different aspects that, a lot of us haven't really thought of, because once you clear your browser history or whatever it is, you kind of are on to the next thing, and maybe aren't taking into serious attention kind of where all of this could head. So thank you all so much for joining us this evening. We really appreciate your time and attention. We hope that you'll continue to check out WooStream in the future. And until then, we hope everyone is staying healthy and safe with their loved ones at home in these difficult times. Take care of yourselves, and we hope to see you soon. Have a good night, everyone.
Thank you, everyone.